Thank you, Kurt. Good morning, and thank you again for the invitation. Um, the title of my presentation today is the 14th Amendment People, and I will mention in a moment the reason why that is so. And we can certainly go to the next slide. On January 2, 1873, Henry Shelby Foote, who defeated Jefferson Davis to become the 19th governor of Mississippi, appeared before the Tennessee Supreme Court on behalf of a man named David Galloway and a woman by the name of Melinda Brendan. Months prior, David and Melinda had been arrested, charged, tried, convicted, and sentenced to imprisonment in Nashville, Tennessee for violating the then state's ban against interracial marriage. That Foote would appear on behalf of David and Melinda for the interracial marriage would seem to be somewhat unusual, if not extraordinary, given his life. For much of his life prior to the war, he was an ardent defender of slavery. During an 1848 debate, he invited then Senator John Hill of New Hampshire to Mississippi so he could hang him from a tree. And then he offered to assist in the operation himself. But Foote was also a Unionist who opposed secession, and while he served in the Confederate Congress, by the time the war was over, he turned Republican. And throughout much of Reconstruction and much of his life, Foote seemed to have stuck to two beliefs. The first was Jefferson Davis was a traitor, and he delighted in writing op-ed letters to the editor, reminding readers that he had once slapped Jefferson Davis in the face, and if Davis wanted to get his revenge, you know where to find him. And the second thing that Foote developed and lived in was this sort of strong belief in the need for strong enforcement to the 14th Amendment. These two beliefs were sort of most evident in first a speech he gave at HBCU Fisk University, where he referred to the black graduates as our people. And the second was a speech that he gave on October 14, 1874, 2 days after Lee's death, in which he joined other officials praising Lee's greatness. But at the same time, and while the speech didn't go over very well, he reminded his audience that it was time to let go of the lost cause and that their job from now on was to defend the 14th Amendment as ardently as they had defended slavery. But Foote's sort of about face regarding the 14th Amendment was perhaps most evident in, strange enough, in a weird role that he played in a relatively obscure event regarding black liberation. It was called the Great Kansas Exodus of 1879, because between 1879 and 1881, tens of thousands of black people basically left the Mississippi Valley heading west for what they thought was going to be a new paradise in Kansas. In time, they came to be known as the Exodusters. The white planters were so concerned about the potential loss of their labor force that they petitioned the then governor of Mississippi to call for a convention, which it did. It came to be known as the Mississippi Valley Labor Convention. And on the second day of the convention, the president of the convention introduced a resolution reaffirming that the white planters would indeed be committed to the 14th Amendment, but that he insisted that the reason why the black laborers were leaving was that they had been misled into thinking that they were being mistreated. Strangely enough, Foote was actually a delegate from Louisiana. And he offered a counter-convention in which he argued, among other things, that the planters had to be more willing to concede that they indeed been trashing the 14th Amendment. Needless to say, it didn't go over very well, and his resolution failed. I say this because, strangely enough, and we can go to the next slide, when Foote appeared before the Supreme Court as the attorney for Brendan and Galloway, he wasn't the only counsel. He was also joined by co-counsel, a name by the name of John Campbell. And the brief that they submitted on behalf of David, we can go to the next slide, is actually a 68 handwritten pages brief, which seemed to have been written quite literally by two separate people. Go to the next slide. The first half of the brief, almost the first 50 pages, is essentially a classic argument that most folks who were arguing against the ban on conjugal marriage would make, namely that the ban violated the 1866 Civil Rights Act, the 1870 Civil Rights Act, that essentially, said that black people had the same right to enter into contract as white people. So the argument was that a marriage is a contract, so therefore you could not impose a ban. But that was basically the first 50 pages. But then the last 10 pages, I think we can switch, suddenly switch. The handwriting switches, and the tone switches, and the substance switches. And in it, the author of the brief, which I've come to be convinced was Foote, whereas the first half was Campbell, essentially gives a full-throated defense of the 14th Amendment and its enforcement. Now, the reason I'm boring you with all this is that, as many of you know, during Reconstruction, Congress had a select committee where that investigated, the enforcement of the 14th Amendment throughout the South. The Select Committee left Washington and traveled to various places to take testimony, and they produced a gigantic set of volume for these reports, really gigantic, thousands and thousands and thousands of pages. And buried in those pages, there's a testimony by a gentleman who complained to the committee that black people were voting fraudulently because they didn't really understand what it is that they were doing, because they were new citizens, they were new people. They had only made people because of the 14th Amendment, whereas people who had been people before the 14th Amendment knew better what they were doing. And that phrase always struck me because it recurs over and over again in testimony, because it came to be almost used as a slur. And I've been fascinated by this notion of these 14th Amendment people. And I spent most of my time, the last 6 or 7 years, writing about these 14th Amendment people, sort of ordinary people who don't necessarily make their way in the pages of history. And I do so because it seems to me that the lives that they led, right, or the lives that they tried to lead, right, and these people were not just formerly enslaved people who became people because of the 14th Amendment, but I think people like Foote were always people, but then became different people because of the 14th Amendment. That their lives stand as sort of artifacts, right, for a time when American jurisprudence in general and constitutional jurisprudence in particular, right, a time when for a brief moment, if you will, between Dred Scott and Plessy versus Ferguson, between the bondage of cotton plantation and the segregation of drinking fountains, between the charnel house of Gettysburg and strange fruits hanging from southern trees, that the world of racial slavery had fallen to pieces and had not yet rebuilt itself into what ultimately became the new social order of racial apartheid. And everything seemed in motion, everything seemed to be in flux, everything seemed to be possible. Everything sort of became strange enough to bring together in one single place people like Foote, David, and Melinda. So what I wanted to do for a moment as I close, and I promise I will not go over very long, can go to the next phase, is to tell you a little bit about an example of these 14th Amendment people, namely David and Melinda, who have basically spent the last sort of 7 years of my life chasing through the archives. And here's what I think I can tell you, that for all the gaps in the written record, and even in the dim light of those passing years, here's what I know. David was born between 1830 and 1835 in Maury County, Tennessee. His last name, Gallery, was taken from his owner. He suffered a cracked skull while he was a young boy. And after, when the war came, he joined the Union Army. But he wasn't assigned to, we can go to the next slide, and the next one. A fighting unit. He was assigned to the 64 Colored Regiment, which was a so-called invalid regiment, who were assigned to guard plantation. In fact, I'm fairly certain David at some point while he was in the regiment happened to guard the plantation that used to be owned by Jefferson Davis and his brother. After the war, he supported himself as a laborer until he was fired for for voting for radical Republicans. I know Melinda lost her parents in one of the Nashville cholera epidemic. I know she lived in an orphanage until she turned 17. When the orphanage closed, she was left with no family and became a prostitute in Nashville, working for a brothel owner by the name of John Overby in a Nashville neighborhood that still exists called Smoky Row. Melinda went by various names, which is the reason why she's so hard to find. One of the names that she went by is Melinda Vines, and I know it's her because the orphanage that she lived on was on a street named Vine Street. And while her name was Melinda Brendan, when she became a prostitute, she changed it to Melinda Vine as the name of the place where she grew up. I know that David and Melinda were together for 13 years, but they spent most of their time in and out of prison because of their marriage. In fact, the first time they were arrested and convicted and were presented by foot was the first time they were arrested. David served 2 years in a penitentiary, but when he was released, he went back to Melinda. And they actually lived together for 10 more years until, strangely enough, a reason that I still don't understand, 10 years later in 1882, Tennessee rearrested them and charged them again and prosecuted them again and sentenced them again to prison. I know that Melinda served her time in prison and was released for good behavior in 1884. And I can tell you I know exactly when was the last time they saw together because they saw each other because they went into prison on the same day. I can tell you, for example, that on the day they went to prison together, David was 53 years old. He was medium built, 5 feet 7 inches, about my size. He was 153 pounds. He was dark skinned. He had dark eyes and dark hair. He had a scar on his face because of the injury he suffered as a boy while he was a slave. I can tell that Melinda was 38. She was 5 feet 6 inches tall. She weighed 145 pounds. She was fair skinned. She had blue eyes. She had sandy hair. Her hair was turning to gray. And in a strange twist, she had a tattoo of a ballerina on her right forearm. I know that David did not survive the second stint in the penitentiary. Barely a few days after Melinda when he went into the prison with Melinda, he was shipped to a mining camp in East Tennessee, where he remained for much of his life, and he died a few months after Melinda was released. A 55-year-old black man, Chocolat Dienko, mining coal for the Tennessee Coal, Iron, and Railroad Company as an inmate in Tracy City near the Cumberland Mountain range of East Tennessee. So I have spent most of my life writing about people like that, David and Melinda and others that perhaps we can talk about today, because my overall thesis is that these 14th Amendment people that most of us never talk about, the way that they tried to live their lives, even if they didn't succeed, tells us a great deal about what they understood that the 14th Amendment meant. Thank you.
Professor Merchant.
Sure. So the title of my remarks today are a summary view of the 14th Amendment. And my remarks today focus on Lincoln's use of the Declaration of Independence to support the Reconstruction Amendments. And I'll start with a seemingly completely random statement. Thomas Jefferson couldn't figure out how seashells ended up on the top of mountains. He just couldn't figure it out. He rejected the proposal of the day that some deity might have magically placed them there. Maybe there's some great explosion that thrust the shells on top of the mountains. Maybe they weren't really seashells. Maybe they just looked like seashells. He asked his friends in letters, how came they 15,000 feet above sea level? This fact is so curious, so circumstantially detailed, and yet so little like any known operation of nature, that it throws the mind into absolute suspense. As humans, we got more sophisticated and we figured this out. Today, it's easily explainable through plate tectonics, but in 1776, science and Jefferson just couldn't fathom this. There's another thing that Jefferson couldn't fathom. and it's an integrated society like the one we got after the Reconstruction Amendments. As we'll discuss, Jefferson was very clear on this point. Nevertheless, Lincoln argued in his Gettysburg Address that 77 years ago our fathers brought forth upon this continent a new nation conceived in liberty and dedicated to the proposition that all men are created equal. Lincoln said of Jefferson in 1859 letter to H.L. Pierce, "All honor to Jefferson, to the man who, in the concrete pressure of a struggle for national independence by a single people, had the coolness, forecast, and capacity to introduce into a merely revolutionary document an abstract truth applicable to all men and all times, and so embalm it there that today and in all coming days it shall be a rebuke and a stumbling block to the very harbingers of reappearing tyranny and oppression." How accurate are these claims about Jefferson? As Michel Rolfe-Troyot has written, and of course other philosophers before him, history includes both what has happened and what is said to have happened. So let's examine the meaning of Jefferson's words in the Declaration, all men are created equal, as he would have understood them. While Jefferson supported emancipation of slaves, he never supported integration of whites and blacks. Instead, as our presenters today know, he supported colonization, gradually drawing off this part of our population and sending them to other countries, most advantageously for themselves as well as for us. He says that the secession of that kind of property, for so it has been misnamed, is a bagatelle, which would not cost me a second thought if a general emancipation and expatriation could be effected. Gradually, and with due sacrifices, money, I think it might be. So, Jefferson supported emancipation, but not integration or citizenship. Why? Well, he tells us that there are irreconcilable differences between the races, and the memory of the horrors of slavery in the minds of both whites and blacks is simply too great to overcome. He says that, quote, "deeply rooted prejudice is entertained by whites, and 10,000 recollections by the blacks of the injuries they have sustained, new provocations, the real distinctions nature has made, and many other circumstances will divide us into parties and produce convulsions, which will probably never end but in the extermination of one race or the other." So he's predicting a race war if blacks are not sent to other countries. He says, "To these objections which are political, many others may be added, which are physical and moral. The difference strikes us is that of color." He continues in the notes of State of Virginia that Africans are, in general, just dumber, uncivilized, and they kind of smell funny. What's important is that Jefferson simply could not fathom an integrated America like we have today. Like the seashells in the mountains, his reasoning was limited by his time and his place. But I think it's inappropriate to hyper-focus on Thomas Jefferson. He gets far too much credit for those words in the Declaration. Richard Henry Lee and John Adams accused Jefferson of plagiarizing John Locke and plagiarizing Congress's earlier Declaration of Resolves of 1774. Jefferson candidly responded that he was not even trying to be original. He was trying to, quote, harmonize the sentiments of the day. I think it's important to trace this history of the ideas that led to those words in the Declaration of Independence. This is hopefully my contribution to this existing literature. Jefferson actually first harmonized the sentiments of the day 2 years earlier in July 1774 in a pamphlet, A Summary View of the Rights of British America. This document started as instructions to the Virginia delegation, but Virginia rejected them. He was so proud of his work that he had his friends publish them. If you read that document, you'll see that the Declaration of Independence of 1776 was largely a recycled version of A Summary View from 1774. He often used the exact same language, but he was much punchier and he was more concise in the Declaration. But what, if anything, inspired Jefferson's words in A Summary View? I don't have time to go over all those remarks today, but I do flesh that out in my paper. But Jefferson relied heavily on James Otis, Samuel Adams, and Jonathan Mayhew, these guys made almost identical statements that Jefferson made, but decades before Jefferson made them. They spoke about inalienable rights to life, liberty, and property that were rooted in natural law. They all enumerated grievances against the king that mirrored Jefferson's, and they threatened that the good people of these colonies, with all of these rights, can't endure these grievances for much longer. Otis, Adams, and Mayhew, in turn, rely on British opposition thinkers, and those thinkers rely on theorists like John Locke and Hugo Grotius. If you look at the catalog of books and documents in Jefferson's library, he had all of these works from time to time, and he spoke incredibly highly of these theorists, especially Samuel Adams. What do these writers who inspired Jefferson think about equality as contemplated in the Reconstruction Amendments? Locke and Grotius believed that slavery was acceptable in cases of a just war, it being better to enslave a defeated enemy than to kill them. But they did oppose the American version of slavery, as obviously inconsistent with things like liberty and consent. And all the early colonial thinkers who inspired Jefferson that I mentioned earlier opposed the American version of slavery as well. But that's not the end of the story, especially for the purposes of the 14th Amendment. While these northern thinkers in Boston opposed slavery, they didn't actually suggest integrating former slaves into American society. At most, they tended to be silent on the issue of what to do with slaves after emancipation. And all the references to all men being created equal, what they're talking about for the purposes of citizenship, privileges, and immunities is that all British citizens are born equal, regardless of whether they're born in America or whether they're born in England. They are all complaining that whites in America are not being treated in the same way that whites in England are being treated. These are the sentiments of the day that Jefferson was harmonizing. They're not saying that everyone, including slaves, should be treated equally under the law, which is what Lincoln was talking about. But by the 1860s, the world was more sophisticated, and the arguments for not including blacks in We the People weren't as powerful anymore. As we know, when Jefferson is citing Lincoln, he's being a creative lawyer who's trying to persuade. I gave you the quotation earlier from Lincoln, where he praised Jefferson, but as Alan Gelzo and others have pointed out, Lincoln didn't even like Jefferson. He thought he was a terrible person for owning slaves and for starting a relationship with a beautiful 14-year-old slave and then enslaving his own children that he had with her. But Jefferson was very popular in American memory in the 1860s, so Lincoln exploited that and reimagined Jefferson's words to argue for an integrated society. I'll stop here for now, but I think this is a modest contribution to this discussion about whether we should focus on 1791 or 1868. I'm not making the unfair claim that the founders should have expected things like the internet or modern guns, but for many of the founders, an integrated society is such a profound and unfathomable shift in how we constitute our society that we should give much more attention to 1868 and beyond than we currently seem to do. Thank you.
So all this talk of the Declaration of Independence has suddenly reminded me to acknowledge the contributions to the conference of the Declaration of Independence Center here, which is providing a bunch of critical AV support. And so if this appears online on their YouTube channel, don't think that they are somehow pilfing a video from the Law Journal. But third, we have Professor Upham.
Hey, good morning. Let me dive into this and try to stay within 10 minutes. Our republic, for nearly a half century now, has officially observed Black History Month. President Gerald Ford began this official observance with a proclamation in February 1976. Since then, every president has done the same and thus established what appears to be a national tradition. According to the original proclamation, it was appropriate to do so in this bicentennial year of our independence. It was important that we should review with admiration the impressive contributions of Black Americans to our national life and culture. We should, he elaborated, seize the opportunity to honor the too often neglected accomplishments of Black Americans in every area of endeavor throughout our history. Today I'd like to speak about one often neglected, but I think impressive contribution made by Black Americans to our common national endeavor, and in this case, the making of our Constitution. In particular, I will speak of the work of the so-called Black and Tan Conventions, the state constitutional conventions held in the former rebel states during Reconstruction. Through these conventions, Southern Black loyal citizens, in cooperation with Southern white loyal citizens, participated substantially in the making of the 14th Amendment, and consequently, I believe, in the establishment of its original meaning. I'll proceed in 3 steps. First, I'll sketch the vital importance of these conventions to the making of the 14th Amendment. Second, I'll sketch what the work of these conventions might tell us as to the original meaning of that amendment. And third, I'll address the principal objections that have been or could have been made as to the value of this contribution. I'll conclude, maybe, if time permits, with a few remarks as to why American jurists in particular have, I believe, unfairly disregarded this contribution. First, it's the contribution. After the Civil War, the Republican, much of this is just review for everyone present here, the Republican-dominated Congress refused to admit any putative representatives from the 11 insurrectionist states. That Congress adopted a number of Reconstruction measures, including the proposal of the 14th Amendment in June 1866. Tennessee's legislature, along with most northern states, promptly voted to ratify the amendment, and its representatives were admitted to Congress. But in the other 10 states, the amendment was emphatically rejected by the putative legislatures chosen by an electorate that included former rebels without discrimination, but excluded all African Americans. Partly in response to this refusal, Congress passed the Reconstruction Acts of 1867 as amended through 1868. Congress thereby declared that each of the 10 states could be represented in Congress on certain conditions, including, among others, the following. The state must first form a constitution that is framed by a convention of delegates elected by and ratified directly by an electorate that was inclusive as to race, but exclusive as to certain criteria of nationality, sex, age, durational residence, and loyalty. More specifically, only American citizens, only males, only those over the age of 21, only those who had resided for at least 1 year in the state, and were both presently loyal to the Union and its Constitution and laws, and in some cases had not been previously disloyal. So present loyalty, and in some cases, no prior disloyalty was necessary. Second, that Constitution must be, and this is very important for our conversation, in conformity with the Constitution of the United States in all respects. And third, that state must ratify the amendment by a vote of the legislature established under that new Constitution. Subsequently, the occupying Union Army registered voters according to these standards. And this biracial Loyalist electorate proceeded first to choose delegates to the state constitutional conventions. Those voters then ratified the state constitutions proposed by those conventions, and then they elected members of the legislature under those constitutions that proceeded to ratify the 14th Amendment. Congress subsequently certified these states as compliant with the Reconstruction Acts and readmitted their representatives to the House and Senate. The contribution of Black Americans to this work was unprecedented. African Americans constituted a clear majority of the voters in many states. They constituted a substantial minority among the membership in the conventions and the subsequent legislatures, and in one state, South Carolina, they were a solid majority of the convention delegates. Never before or since have black voters and black officials played such a primary role in the making of our federal and state constitutions. The contribution was necessary to the making of the 14th Amendment. Article 5 of the Constitution requires ratification by 3/4 of the states, but by March 1868, only 23 of the 37 states had ratified. At least 5 more were needed, and the biracial Southern Loyalists provided 7 more ratifications so that by July 1868, Congress could declare that the amendment was ratified. And over the next 2 years, three other Southern states would do the same, including Mississippi, Texas, and Virginia. If these states had not ratified, it is highly unlikely that the amendment would not have succeeded. Even the rapid addition of Western states would not have been effective, because public opinion in the West was not friendly to the measure. It was rejected in California by one house of the legislature. Oregon barely adopted it, and in fact subsequently rescinded. And it's highly likely that if Colorado and a number of Rocky Mountain states had come in, that they also would not have ratified the amendment. Therefore, as Eric Foner has noted, but for the work of black voters, the amendment would never have been adopted. And by the work here, we should understand that all of this was done under periods of great deal of stress and threats of real as well as prospective violence. That is to say, but for the blood, sweat, and tears of black and white loyalists in the South, we would not have the 14th Amendment. The contribution here is not only to the making, but also the meaning of the amendment. Recall that the Southern state conventions met under a peculiar mandate. They had to make a constitution that was in all respects in conformity with the Constitution. Hence, by making these elaborate constitutions, and by Congress accepting the same, the members of the conventions and Congress certified the full constitutionality of these constitutions. Moreover, this certification impliedly extended to conformity with the 14th Amendment, and for 2 reasons. First, many believe that the amendment had already been ratified by force of an argument, a loyal denominator, that we didn't need the 10 states to be even counted among the denominator. Or second, all believe that the amendment represented restatements or elaborations of principles already present in the tenor or spirit of the Constitution. That is to say, the 14th Amendment was merely a restatement and elaboration of what was already in the letter or spirit of the 14th Amendment of the Constitution of 1865. Hence, this state's Supreme Court in 1873 explained that those conventions had to conform with the Due Process Clause of the 14th Amendment. Even though the amendment was not yet adopted, that clause was already, the court said, substantially the law of the land because the principle was already in the Fifth Amendment. This certification by state conventions and National Congress is very important evidence as to the meaning of the amendment. For originalists, it would be important because the certification happened during the pendency of the amendment by public officials seeking to conform with the amendment. So 7 of the 10 constitutions are of real significance here because these 7 were made and accepted before Congress declared the amendment was ratified. The post-1868, post-July 1868 constitutions represent post-ratification evidence and would be less important to determining the original meaning. As such, the contents of these constitutions should be considered by anyone seeking to recover the original meaning of the 14th Amendment. And in particular, these constitutions provide strong evidence of the following. First, they provide strong evidence of the governing principles. What were the general opinion of the most important principles of government? The underlying spirit, motive, and purpose of the 14th Amendment, even if not the letter of the amendment. For one sees at the very beginning of these constitutions that the authors had a certain priority of things they wanted to say. In nearly all of them, they began with initial statement of gratitude to Almighty God. Second, they began with a statement identifying the sovereign people as the earthly political authority to make constitutions. And third, as the first provision of their Bill of Rights, usually Article 1, Section 1, a restatement of Declaration of Independence, principle of universal equality and rights of all human beings. Second, one can see in these constitutions evidence that's very relevant, although it's not dispositive, as to the meaning of due process of law and the privileges and immunities of citizens. If, as I believe, due process of law originally was understood to require conformity, according to the Supreme Court, with those settled usages and modes of proceedings of Anglo-American law, the fact that all of these conventions included jury trial in criminal cases, writ of habeas corpus, and a restatement of the English Bill of Rights and the Eighth Amendment against cruel and unusual punishments, etc., that's strong indication that that's one of those settled usages and modes of proceeding that was already part of due process. It's also, I think, important, relevant evidence as to the meaning of privileges and immunities of citizens, if, as I believe, it required it incorporated the standard of Corfield, rights that belong to citizenship in all free governments since the time of their becoming free, independent, sovereign. It matters that those state constitutions, many of them, spoke about 3 rights in particular as essential to citizenship: freedom of speech and assembly, right to bear arms, and in many states, freedom from racial discrimination as one of the immunities of citizenship. Third, and most important, the state constitutions provide powerful, if not dispositive, evidence of what the 14th Amendment, as originally understood, did not forbid. By endorsing these constitutions, the conventions and Congress certified that the contents thereof were not inconsistent with the Constitution in any respect. And of relevance to some cases of the 20th and our century and our time, Congress, the states endorsed and Congress accepted constitutions with the following provisions, at least in some of them. First, a ban on any and all racial distinctions in some of them. We might call it colorblindness. I would say color regardlessness is mandated in some, but not all. Second, not only an acknowledgement of Almighty God, but the duty to promote religion through education, as well as special laws to protect religious associations as such, special corporate privileges for religious associations. And in some cases, exclusions from office for those who denied God's existence. Third, rampant sex discrimination as to civil rights. This took the form, and I'm being provocative just for the sake of illustrating, form of taxes and duties imposed only on males, the modification, but not wholesale abandonment, of the unequal laws of marital coverture, and in one state, an express constitutional mandate of sex segregation in prisons. Fourth, in all the states, rampant discrimination as to voting rights, including all the exclusionary rules of nationality, sex, age, durational citizenship of 1 year, and loyalty mandated by Congress, and widespread geographically unequal districts, including the requirement that certain counties automatically get a certain number of seats in the state Senate. And last, in some states, enhanced loyalty oaths, with voters having to promise or support not only the Union and the Constitution, but as a condition for voting, they have to promise that they support the civil and political equality of all, regardless of race. The inclusion of these measures, of course, did not imply that the 14th Amendment compelled such requirements. Contrary to some scholars, I do not think it fair to say that because all of the state constitutions moved in the direction of schools, that schools' education itself was required by the 14th Amendment. But it does indicate that what's in these constitutions was certified officially by state conventions, ratified by the people of the states, and certified by Congress as in conformity with the 14th Amendment. I'm going to close just briefly enumerating the various objections that have been or could be raised to my claim that these conventions are really important to the making and to the meaning. First, that their work was unnecessary because the amendment was already ratified. Second, it was unrepresentative because it included too many people, the premature, as to your comment, the premature inclusion of blacks who were not yet citizens. And so they shouldn't have been voting until the 14th Amendment is ratified. Conversely, the allegedly unjust exclusion, chiefly on the basis of sex and loyalty, which made a big difference as to who could vote. Third, they were unfree because Congress made them do it, because the Reconstruction Acts forced them, quote unquote, to do so. And lastly, one might say it's unimportant because their constitutions don't include many novel things. They seem to just restate declaration and restate things that one could find in the state constitutions that were ratified at the same time, drafted by northern states. Perhaps during the comment period I can defend and try to answer some of those objections, but I seem to have run out of time, so thank you.
Question for Professor Merchant. So, Jefferson, doesn't know science of geology. He pretty clearly doesn't know. So would he have said that race is a natural kind in a way that we just know based on genetic stuff we know about? Really, I think they probably had enough evidence to know that it wasn't a genuine natural kind in the 18th century. But what was his view of science? And particularly, I'm curious not just about Jefferson, but about the argument for equality. What was the rationale for it? During Reconstruction, you find piles and piles of people talking about the fact that human beings all have the same nature. They frequently, so in Dred Scott Curtis's Descent, talks about African Americans. They have eternal souls, just like the rest of us. So it's very much like kind of Merchant of Venice. If you cut us, do we not bleed? Well, obviously, we're human beings. Lots of biblical citations to Acts 17. God made of one man all the nations of the earth. That kind of stuff. To what extent is that a big 18th century theme? Obviously, Jefferson, doesn't, he has his bowdlerized version of the Bible where he takes out all the miracles, and you got a lot of deism, a lot of more kind of conventionally religious folks during Reconstruction, at least the ones who were talking about stuff. To what extent is there a kind of a change in the argument for equality between the founding and Reconstruction?
Yeah, I think Jefferson's a polymath, and I think he is well studied in the sciences. But I think just scientific racism was much more prevalent in his time than it was in the time of Reconstruction. And so I think he's convinced by some of the science at the time that talked about appreciable differences between the races in terms of biology and evolution starting to get off the ground eventually. So I think he sees sort of the scientific racist approach being legitimate at the time. But I also think that what he's doing in the Declaration is not really speaking to that. He's sort of looking at how you how you constitute a society and the government's relation to its people, and not necessarily making a scientific claim about the equality of rights of people in the same way that we might be talking about in Lincoln's era. So I think the Declaration does a different thing. I do think that sort of, if I'm imposing sort of modern nomenclature on this, he would say that sort of all humans were equal in terms of rights, but that doesn't mean that they can be included in what we're trying to do in America. They need to be excluded. Kermit Roosevelt has this idea, other people have this idea of insiders versus outsiders. And I think that's kind of how Jefferson thinks of it. We have insiders, that's what we're talking about with the Declaration. And outsiders can be in their own country. They're still equal, they deserve liberty, they have these natural rights, but they're outsiders that sort of should be in their separate country.
Okay, so Professor Upham, the video may have been focused as Professor Upham was given all this stuff about how the 14th Amendment wasn't the law in February 1867. You may have noticed when he said, when he referred to this view, the loyal denominator view, I held up my fist. So while I'm on the video, I just want to say nobody thinks that except Crazy Green, and I don't know. I think I've maybe my kids, who haven't had a chance to look at it. But notwithstanding that, I think these are crazy important reflections of the meaning of the 14th Amendment itself. I find myself, kind of embarrassed that I can't remember the content of these as well as I should. There are lots of arguments, like in the 40s, in the big arguments against incorporation of the Bill of Rights. A bunch of people say, hey, they didn't have grand jury rights, so you can't have total incorporation. Justice Black has got to be wrong because Congress is perfectly fine with not having grand juries. Did they? So I have a couple questions. Did they have civil juries? Because that's also not been incorporated. And I don't think any of them said we need to have equal protection of the laws. And I think that's pretty powerful evidence, if it's true, that Yick Wo is wrong to say the equal protection of the laws is the protection of equal laws. So civil juries, equal protection. What's in them?
Yeah, and that's the Fairman-Kroski debate that is part of the chapter of 14th Amendment originalism, 1940s and 50s. And Fairman points out, made the argument I made here with respect to lack of grand jury indictment apparently in one state, and definitely a limitation on civil juries. And on the second point, it's actually clear. Kroski's only response to that is Congress probably didn't read those very carefully, and also that the conventions themselves were under duress. So the only thing we have to ask is whether Congress read it and they certified it without actually paying attention that it was violating the actual 14th Amendment. They were told them to obey, and that also goes to whether these conventions were acting freely or whether they were under duress. And so we don't need to. It's not about the original meaning because they had.
And that's crazy, right? I mean, they looked at these carefully. I mean, they were, like Mississippi, we come in and the Readmission Act says, hey, great Constitution, we want to put in a fundamental condition that you never repeal this one or this one or this one, things that were actually repealed in 1890. So, I mean, just there's a lot of evidence, I think, from 1868 that they were looking at these very carefully. I mean, they had a whole bunch of them to review in that spring, but, I mean, Kroski was a very creative fellow. Bless his heart. But I mean, they looked at him carefully, right?
I think so. I mean, obviously everything is. I'd say it's probably the evidence is like 80-20 because there are instances where they just. But some, yeah, they're. Be quiet.
Oh goodness! So we've got our later several of our later panelists. Why don't I pass the microphone? Introduce yourselves, and then say your question.
Hi, I'm Lucian Ferguson. My question's for David. So fascinating to hear that states adopted sort of there was local variation in terms of the way that states reformed their constitutions to ratify the 14th Amendment. So I was curious as to whether you thought about how that bears on states' duties and authorities under the 14th Amendment sort of more broadly. So you mentioned that some states inserted, essentially color. You didn't say color blind, but colored. Regardless,
don't
right?
Look at it. That's not that we don't see it, but don't look at it.
We don't look. Okay, right. So so I'm curious whether you have thoughts about how that bears on states' duties and rights with regard to racial discrimination laws today.
I guess that was one of the big points that I have for this conference, and one of the reasons why I think these conventions have not had as much prominence is because they do not give a slam dunk argument for either segregation or not, is it constitutional, or affirmative action or not, is it constitutional? And the reason for that is, as Michael McConnell pointed out, although, for example, on the segregation issue, although we see evidence that they refused to include it because they thought it might be a problem, they thought it might be a problem maybe for others or some in the convention. Soon after the convention, the North Carolina governor, they said, let's ratify this amendment. He says, we got to have segregated schools. And so you see that there is a shyness about including it in state constitutions. There's a sense that it might not be. So it's not going to be a slam dunk for the segregation argument to say, well, everyone accepted it. They plainly were. They knew there was an issue. Somebody was going to oppose this. Not maybe just Sumner, but others. But at the same time, the majorities of the conventions, and no, it wasn't just the white delegates, did support some degree, especially in the South, of school segregation. And that makes it complicated. And the same thing applies to this question of race preferences. I found this really interesting account here of the Radical Republican Convention in Louisiana, not the party convention, not the where they put in there a plank that says, I can't bring it up, that says, we will not support any candidate if they do not support 50% quotas for political appointments. We're going to have 50%, it's a naked, just pure 50% for political appointments and offices. And at the convention, there is a discussion. Everyone's in favor of it, but they say don't put it in because some of our northern friends are not going to understand. They're more in favor of this colorblind approach, whereas we understand the political situation here. And it's interesting that it is voted in, and the response is, yeah, we know that, but we need to also have enthusiastic black turnout here in Louisiana, and we're not going to get it if we don't have this guarantee, So, and it shows that that's on the table among people that support the 14th Amendment. It also shows that people know that other supporters of the 14th Amendment, perhaps regionally divided, might have different opinions as to these kind of remedial, we would consider aggressive remedial measures.
Okay, first, thank you very much for terrific presentations. I'm wondering if I could add 1857 to the 1776 and 1868. It goes, for all three of you, like this. The 20 opinion in Dred Scott essentially says a citizen comes with a very robust set of rights, and if you're denied any of them, that shows you're not a citizen. Curtis says, oh, citizenship doesn't come with almost anything. So maybe you get to call yourself a citizen. If you've got anything in the package, you're a citizen. One of the things I think Randy, among others, has shown is that abolitionists took the 20 view on citizenship with the proviso that blacks with citizenship and ought to have had the full package. And the question is, based on your research, was the 20 view the more common one in the 1840s and 1850s when we weren't thinking of race at all, but simply thinking of what came with citizenship? Or was the Curtis? My hunch is from reading it's the 21. And this, I think, has implications for Section 1 of the 14th Amendment and citizenship.
Somebody read a dissertation about Article 4 of citizenship and all the different views.
I don't mind jumping in. Important to think of three different views. By 1857, you have at least three different views. You've got the Tawney view, which is there. You've got the Curtis view, which represents Northern Democrats. And think of it as very similar to Stephen Douglas's approach. Every state can decide all this question for themselves. The status is one thing. The rights you get are going to be really a very strong 10th Amendment states' rights approach. But the growing opinion among the new Republican Party, and not just people that call themselves abolitionists, is yes, there's a national rule of citizenship, and it ought to go with it certain substantive rights. And that the first time that debate comes up huge is in 1820, when Missouri proposes a constitution that says free blacks can't come in the state. And there is not just a minority, but the northern states are outraged, especially in the New England states, because they say, well, blacks are citizens in our state, and if they want to go to Missouri, they should be able to go there. So the rights of travel, residence, free speech, commerce, civil rights should be enjoyed nationally. But I think that the third view, which probably McLean, if he had written a longer opinion as the only Republican, would have said, is not a dominant view. It is a view, but it overwhelmingly dominates the Republicans who make the 14th Amendment. That's the abolitionist view / growing Republican view, that yes, citizenship is a national standard, which will eventually be incorporated into the Citizenship Clause, and yes, there are fundamental rights of citizens that should be enjoyed, civil rights, not political, it's a different issue, that should be enjoyed in every state by Americans. And Tony's view is the same, but he has a very different conception of who are the citizens.
My name's Seth Tillman. David, I have a question for you. It's sort of an empirical question. Do you have any sense with regard to these Reconstruction era constitutional drawing conventions, how many of the members were members of the state legislature or flowed from other state offices, or alternatively, how many of the members of these Reconstruction conventions then flowed out into the state legislature or other state offices? And just let me follow a third choice. Is your sense, if you have one, an empirical sense, when people in these states looked at these conventions, did they see these conventions as a one-off thing, and conventions were fairly exceptional, or part of what might be a long-range, repeating every 20 years process, as I think Jefferson talked about, where conventions were part and parcel of the regular government of the United States, meeting irregularly, but part of the government, much like legislatures were or governors were? You might not have an answer to those things, but if you happen to have one, that'd be great. Or anyone else in the panel?
I don't know at all, but one thing I will say, there were a number of what were called carpetbaggers. That's a good number of the whites that were elected by the black electorate were considered to be not really of the state, and that did weaken, in part, some of its acceptance.
Professor Merchant, I was wondering, so your sort of main point was that we should focus more on the 1868 history as opposed to founding. And, when we talk about originalism, typically you look at history, and then Reconstruction Amendment, of course, we look at the Reconstruction history. So I was wondering, it seems like you were speaking to some kind of background. There's like a motivation for this kind of point, right? So I was just curious about that, right? Do you hear in the public rhetoric a lot of emphasis on the founding, much more so than Reconstruction era for the Reconstruction Amendment? And then I guess, or was it specifically about how do we think about Declaration of Independence as we interpret the 14th Amendment?
Sure, and it's a great question, and I am commenting on sort of this debate that at some point the court's going to have to resolve between 1791 and 1868. I think they sort of kick the can down the line in a lot of cases. So, Bruin says at some point we're going to have to decide this. The concurrence especially says at some point we're going to have to decide this. Justice Barrett and Rahimi sort of starts to reiterate this as well. So I'm kind of commenting on that point, and also this point of, I guess, what I term snapshot originalism, where you look at history at a snapshot in time, or maybe a year or two around ratification, and that's it. I tend toward an approach that I think would focus more on tradition instead of a snapshot. And if we look at tradition, it's a much larger time span of the relevant time periods instead of a snapshot in time. So that's kind of looming in the background of this discussion about what time frame we should look at for relevant information. And a part of that is, after the 14th Amendment, it's such a revolutionary change from what the founders envisioned that maybe we should start taking more seriously 1868 and on, or 1857 and on, but just sort of the more recent history.